Section 4. Permissible defenses to a defamation claim. 4. Section 4. A is illogical and redundant. Defamation by definition is an untrue statement. Accordingly, Section 4(d) makes truth a defense to any claim of defamation. Thus, it is entirely irrelevant if the statement was made while performing journalistic activities or some other activity, or whether it was made for the information of the public or for public entertainment or in pursuit of a political or personal interest. So long as it is true, it is not actionable. This has been law for hundreds of years, right from the very inception of the tort of defamation. As such, the needless addition of Section 4(a) shall only give rise to confusions and conflicting decisions and complicate matters for defendants. 5. Similarly, Section 4(b) is also illogical and redundant. The classical defenses to a defamation claim are that the statement was true and amounted to fair comment, that is, a bona fide expression of opinion and not a statement of fact, or C, D, and E of the bill. What is the purpose, then, of prescribing it shall be a defense if the statement is made while analyzing or discussing in a fair and transparent manner on an online platform? Does this mean that it shall not be a defense if the statement was made on television or an offline platform, or if made during a speech and not during analysis or discussion? Once again, Section 4(b) only creates further confusions and complications. 6. Moreover, although Section 4(c) of the bill merely sets up the classical defense of fair comment, it is important to point out the defense of fair comment to a defamation claim has been judicially defined on many occasions. The legal definition of fair comment is quite different to the ordinary layperson's understanding of the term. Fair comment does not only mean expressions of opinion that are fair and reasonable. Rather, it includes expressions of even stupid and irrational opinions, so long as they are honestly held by the person expressing them, that is, are not the outcome of deliberate mendacity. Otherwise, it would mean effectively outlawing any expression of opinion that a judge considers unreasonable. While this distinction is well understood in judicial precedent relating to the law of defamation, if this exercise of amending the law is being undertaken, it would be much more appropriate to define the defense of fair comment in a way that its true meaning is clearly evident to the layperson. Section 8 and 9. Establishment of an exclusive tribunal to hear defamation cases. 9. The provisions of the bill relating to the appointment of members to the special tribunal for trial of defamation cases run afoul of Article 175 and 203 of the Constitution, which mandate a separate and independent judiciary and require all judicial forums in a province to be under control and supervision of the provincial high court. The Supreme Court has interpreted these constitutional provisions as requiring that the appointment, discipline, and removal of judges should primarily be under judicial control. While Section 8(3) of the bill does conceive the consultation of the provincial chief justice in respect of appointments to the tribunal, it allows far too great a discretion to the provincial government in this regard, allowing it to practically control or nullify the recommendations of the Chief Justice. 10. Moreover, under Section 8(6), bill allows special tribunal to penalize those involved in drafting or disseminating fake news. Opposition lawmakers tear up copies of bill. Press gallery sees walkout against hasty adoption of black law. The SIC members tore apart copies of the bill after the House passed it through a voice vote. Vetted by the Special Committee 1 in the absence of standing committees, the bill was tabled by Punjab Finance Minister Mujtaba Shujaur Rahman after the PMLN government refused to delay voting on the bill, even for a week, at the request of journalists. On the occasion, the press gallery members walked out of the assembly to boycott the proceedings. They rejected the bill as a curb on free media, approved inappropriate disciplinary proceedings, merely as per the will of the government or even the Chief Justice. 12. To this extent, therefore, the bill appears to be clearly unconstitutional. Section 10. Jurisdiction of the Tribunal. 13. Section 10 vests the tribunal with jurisdiction over any claim in respect of any defamatory material that has been disseminated, circulated, received, read, or viewed within the territorial precincts of Punjab, or which has resulted in the defamation of any person who resides, works for gain, or discharges his functions, duties, either permanently or temporarily, within the territorial limits of Punjab. 14. Thus, Even if a newspaper is based in Sindh and circulated exclusively in Sindh, but is carried by a third person to Punjab, where it is read or viewed, a claim can be filed before the tribunal in Punjab. Even more astonishingly, if a publication or a speech takes place outside Punjab and is never disseminated or viewed in Punjab at all, but is nonetheless alleged to have defamed a person who resides or works, permanently or temporarily, in Punjab, a claim may be preferred to the said tribunal. 15. This is a patently extraterritorial application of provincial laws and expressly barred by the Constitution. By this legislation, the province of Punjab seeks to apply its defamation laws and its restrictions on speech indirectly upon persons in all the other provinces. ये तो दूसरे सूबे कह देंगे कि हमारी jurisdiction को क्यों encroach कर रहे हो. Section 11 and 23, Procedure of the Tribunal 16. Section 11(3) allows constitutional office holders to file claims before the tribunal through an attorney or authorized officer without needing to appear personally. On its own, such a clause is unexceptionable. Civil cases are often preferred through attorneys or agents. However, Section 11(3) further provides that any statement made by the attorney or authorized officer shall be deemed to be a statement of the holder of constitutional office. The bill says the government will provide legal assistance to women and transgender individuals in defamation cases through an official legal team. The government earlier did not agree to send the draft bill to a selected committee comprising opposition members to invite all stakeholders for consultation, saying it had already been discussed threadbare by the special committee. On the occasion, the press gallery members walked out of the assembly to boycott the proceedings. They rejected the bill as a curb on free media. In the present case, however, Section 23 of the bill expressly excludes the application of the Kanuni Shahadat Order 1984 to proceedings before the tribunal. QPS. So, how will you cross-examine the attorney? 18. These extraordinary exemptions made available to constitutional office holders are violative of the guarantee of fair trial and due process enshrined in Article 10A of the Constitution. Moreover, they are discriminatory and infringe Article 25 of the Constitution, as there is no reasonable cause or intelligible differentia for granting such privileges to constitutional office holders. Indeed, the consistent jurisprudence of our courts and in democratic countries globally is that public office holders enjoy a less privileged and not more privileged position when it comes to maintaining actions for defamation. They must be prepared to face harsher, even unfair and unreasonable criticism, and be less sensitive than ordinary private citizens. That is the very essence of accountability in a democratic system. Section 12. No comment on proceedings before the tribunal. 19. Section 12 imposes a blanket prohibition on making any statement or comment on any proceedings pending before the tribunal with no exceptions and rules out any defense whatsoever, even fair comment or any good faith expressions of fact or opinion. This kind of blanket prohibition is unheard of in our constitutional jurisprudence and essentially amounts to secret trials in violation of Article 10A, 19 and 19A of the Constitution. Section 13. Leave to defend. 20. The bill makes every effort to make it as difficult as possible for a defendant to defend himself against a defamation claim. First of all, it bars them from even defending themselves unless they obtain leave to defend from the tribunal. While this concept is not entirely unknown to our jurisprudence, it has hitherto only been applied to suits on negotiable instruments, that is, bounced checks or banking suits, where the main underlying facts, that is, the issuance of checks or availing the bank loan, are rarely in dispute. In defamation cases, of course, the truth or falsity of the allegedly defamatory allegations are disputed in most cases. As such, it is unreasonable to insist upon obtaining a leave to defend from the tribunal before one is even entitled to enter defense. This is compounded by the fact that Section 11(9) of the bill permits the tribunal to impose conditions such as deposit of cash. 21. Section 13(1) further provides that in case the defendant is unable to obtain leave to defend or meet the conditions for grant of leave to defend, a preliminary decree for general damages shall immediately follow. No proof of any actual harm to reputation, see Section 17, shall be required in order to obtain a decree for general damages. The publication of any statement that tends to lower a person in the estimation of others or exposes him to unjust criticism is sufficient, see Section 2H, to sustain a defamation claim. Proof of actual losses of the plaintiff or of bad faith or repeated misconduct of the defendant are only required if the plaintiff is seeking special or punitive damages over and above his claim for general damages. Moreover, as per Section 2K, the minimum amount of general damages shall be not less than PKR 3 million. As such, even the most trivial defamation case shall lead to automatic grant of damages of PKR 3 million. 22. This weaponization of defamation laws shall have a seriously chilling effect on the freedom of speech, both for individuals who may be harassed for even the most casual cases of defamation on a tweet or social media post. Similarly, for media organizations who face dozens or hundreds of such claims every year, the prospect of depositing or paying PKR 3 million for every such claim shall effectively prohibit free reporting. Section 16 and 18. Execution and ex parte proceedings 22. After a preliminary decree is pronounced. 21. Blocking a platform of the defendant 23. In addition to passing a decree for damages and directing an apology, the tribunal may also direct the blocking the social media account or any other medium or platform on which the defamation occurred. In other words, if defamation is found to have occurred, directions may be passed not only to block a website, YouTube channel, or Twitter account, but even block a newspaper or a television channel. As stated earlier, the bill covers all types of defamation 24. For media organizations that confront numerous defamation claims annually, this shall be like a perpetual sword of Damocles. Any mistake could potentially lead to ending their very existence. Such draconian penalties shall seriously stifle the freedom of speech, even on issues of great public interest. Section 26. Appeal right to appeal after depositing 3 million. 25. Appeals against decisions of the tribunal are made subject to deposit of the decretal amount, which, as pointed out earlier, shall be PKR 3 million at the very minimum. Needless to say, this severely restricts the right of media organizations, who may be facing dozens of such claims at any time, to challenge the correctness of the tribunal's decision. For private individuals facing a claim against a Facebook post or tweet, it may effectively rob them of the right to appeal.